Hello, guys, and welcome to today's session. And in this session, we will be discussing one of the most fundamental aspect of our democracy. That's the fundamental rights enshrined in the Constitution. So these rights are crucial for understanding how Indian legal system safeguards the freedom and dignity of its citizens. All of us. And today we will discuss the origin, the significance, and the detailed features, and some landmark cases which are associated with the fundamental rights. So I'll go for a quick recap of all of these. And in case if you're looking for the complete course, exclusively on polity or complete GS course, I'll give you the link in the description. You can consider subscribing that. So let me share the PPT. With the help of it, I'll be explaining things. Right, okay. So guys, I hope you can see the screen. Great. Okay, now let's move on to historical background. Okay, so to understand the fundamental rights, we need to go back to the origin, right? And if you see in the US, these rights are known as Bill of Rights, and that guarantee basic freedoms to people, the citizens. Okay, and the inspiration of India's fundamental rights was taken from the US Constitution. So that reflect the need for essential safeguards in any democratic setup. And in India, fundamental rights are detailed in Part 3 of the Constitution, covering Article 12 to 35. So the drafting committee, influenced by Magna Carta of 1215, included certain rights to ensure that political freedom and equality were upheld. So it was actually influenced by Magna Carta and the base American Constitution as well. Now, why these rights are called fundamental? So let's look at the significance of fundamental rights. So this is a question one might always ask, right? Why these rights are referred to as fundamental and fundamental rights and fundamental of all and everything? So the answer lies in their importance for the comprehensive development of individuals and their necessity for existence in a civilized society. If these rights are not guaranteed to you, not only guaranteed, if these rights are not protected to you, or guaranteed or given to you, you cannot have a proper civilized life. Okay, so to ensure a civilized life, that's a most important reason. So these rights form the foundation of personal and collective freedom, enable the individuals to pursue a dignified life. And without these rights, the true essence of democracy would be compromised, and it won't be a proper democratic setup. So let's look at the key features. Okay, so key features of fundamental rights. It acts as a check on state's power, and it is applicable against state also, and it's not absolute in nature. And the suspension concept during the emergency, which one by one I can quickly give you an idea. Let's start with the first one: act as check on state power. So, guys, fundamental rights act as a safeguard against the absolute power of the state. So they impose restrictions to prevent any arbitrary action by the government, and with that actually protecting the rights of individuals. Now, coming to this applicable against the state, the rights are enforceable against the state and public authorities, not private individuals. So this ensures that any violation by the state can be challenged in a court of law. Now, coming to the absolute nature, it's not absolute in nature. So these rights are subject to reasonable restrictions for maintaining public order, morality, and security. Suspension during emergencies. See, certain rights can be suspended during the national emergency, such as Article 19, which deals with freedom of speech and expression. But Article 2021 ensuring protection in respect of conviction of offenses and the right to life and personal liberty, etc., which cannot be suspended even during an emergency. So Article 20, 21, you cannot suspend even during an emergency. So 20 is basically giving protection in respect of conviction for offenses, and 21, that's the most important right of all the fundamental right, which have multiple definitions and meanings, that is right to life. Okay, so these two cannot be compromised or suspended. Now, coming to the amendment of fundamental rights. See, guys, originally, Indian Constitution included 7 fundamental rights, but the 44th Amendment Act of 1978 resulted in the removal of one, that is a right to property. So this right, which was part of Article 19, Clause 1, Subclause F, and Article 31, was transformed into a constitutional right under Article 300A. So now right to property is a constitutional right and not a fundamental right after 44th Amendment Act of 1978. So this amendment was, essential for balancing public and private interest, especially in land acquisition and related matters. There were a lot of disputes and other things at that point of time. So that's actually the reason. Now let's look at a detailed overview of these three articles. I told you the continuation we can do later, or you can consider the course. So, see, Article 12, it basically defined the state. Okay, so it includes the executive, legislature, and at both union and state level. So, executive and legislature. So, union, state level, and also the local authorities like panchayat, municipal boards, etc. So this definition is very critical because it determines which entities can be held accountable for violation of fundamental right. So when you say state, you need to have a very clear definition because you are making someone accountable for violation of any fundamental right. So this make it very clear. Now Article 13 emphasize the supremacy of the constitution, and it ensures that any law inconsistent with fundamental rights is void. So this article basically provides the judiciary with the power of judicial review, and that's again one of the most important element. Okay, so this enable the courts to nullify the laws which infringe the fundamental rights. So if any laws which is passed by the parliament or the legislature, if that curtail or infringe the fundamental right, it can be challenged in court of law. There will be judicial review and can be nullified. Coming to Article 14, that is basically about right to equality, establish that every person is equal before the law. So this means that the law should treat everyone equally, regardless of their status or position. Article 14, basically embodies the rule of law, which has roots in the English legal system, the equal protection of laws, basically taken by the American Constitution. So equality before law from English law and equal protection of law from American Constitution. So these questions can be asked in prelims. Now coming to case related to Article 12. See guys, understanding the key case laws helps to illustrate how Article 12 has been interpreted over the years. If you see the first case here, University of Madras versus Shantabai. So the term, this, I don't know how you pronounce it, Aegisdem generis was introduced. So meaning is the same kind. So the Supreme Court held that only authorities performing sovereign functions fall under other authorities. Okay, so that's one point. Now coming to the case of Electricity Board of Rajasthan versus Mohanlal. So the court expanded this interpretation, stating that any authority created by the Constitution or statute would be included under other authorities. So we are evolving, okay? And in the next case, Ajay Hasia versus Khalid Mujib. So it outlined a test to determine whether an organization qualifies as other authorities. And here the test included factors such as the extent of government control and public importance of the functions which is performed. Okay, now let's come to next slide. Judiciary as a state. Right, see the question is whether the judiciary falls under definition of the state has also been debated multiple times. And in Premchand Garg versus Excise Commissioner, the Supreme Court concluded that judiciary could be considered the state when performing non-judicial function like rule making. However, in AR Antule versus Nayak case, it was clarified that judiciary is not the state when performing judicial function. So see, when rule making cases, in such kind of cases, judiciary may be a state. And if in case of judicial functions, judiciary cannot be considered a state. It is entirely different. So that's the clarification which is given. Now, we will also discuss about this doctrine of eclipse and severability. So guys, Article 13 introduced this crucial doctrines of doctrine of eclipse and doctrine of severability. So doctrine of eclipse, if you see, the state that a pre-constitutional law which is inconsistent with the fundamental right is not void but merely eclipsed and can be revived if the inconsistencies are removed. It will just be there, but it is not void. It is eclipsed. Okay, and this doctrine was established in Bikaji versus State of Madhya Pradesh. Now, whenever the fundamental right or any such modification comes, and if it is not going to violate the fundamental right at that point of time, it will become active again. Coming to doctrine of severability, this doctrine implies that if any part of statute is inconsistent with fundamental right, the only the problematic section become void. So there is a law out of which one section of the law may be violating fundamental right, then that becomes void. Okay, that's what's doctrine of severability, while the rest remain valid. So if any part of the law violate fundamental right, that will become void. Okay, and the case of a state of Bombay versus FN Balsara is a prime example where only the offending provisions are struck down. So you check the law, and if there is any provision of the law which violate the fundamental right, only that portion will be nullified. That's what severability. Now coming to the power to amend fundamental rights. Guys, the question is, can fundamental rights be amended? So the question has been explored in significant cases. If you see Shankari Prasad versus Union of India, it upheld that the parliament could amend the fundamental right. But if you see finally the Keshwanda Bharati case, the balance has been came that there is a basic structure doctrine and any amendment can be made by parliament, but it should not affect the basic structure doctrine. Now, coming to Golaknath versus State of Punjab, it overturned the above Shankari Prasad case ruling, and the parliament could not amend fundamental right if it infringed any one of them. Okay, that is the Golaknath case, and it has been again clarified in Keshwanda Bharati case versus State of Kerala that struck the balance by stating that while Parliament has the power to amend the constitution, including the fundamental right, but it cannot alter the basic structure. So this judgment basically introduced the concept of basic structure, which include democracy, secularism, and these important features of the constitution, and that ensure the essence of the constitution, and that should remain intact. And in no circumstances, no situation, it could be altered. So that's about the session. Let's conclude now the significance of fundamental rights. So see guys, the fundamental rights are integral to protection and empowerment of individuals in India. So they act as safeguard against the misuse of state power and provide a framework for equality and freedom. So the judiciary has played a vital role in interpreting these rights and ensuring their protection. So understanding these rights and the significant cases which we have already discussed related to this fundamental rights help us to appreciate the depth and strength of Indian Constitution. So that's about this session. In case if you're looking for any mentorship program for civil services, you can get in touch with us. Or if you are looking for any courses directly, you can subscribe. And that's it, guys. Thank you so much for joining. See you in the next session.